Today I'm showing you exactly what to check before you release a trustee from a Florida trust. I'm Santiago Cueto, board certified international business law expert and best-selling author. I've spent years handling trust disputes in Florida courts, and I've seen what happens when beneficiaries don't protect themselves. All right, you're about to sign that release form for your trustee. The administration's almost done, everything seems fine, but wait. The signature could cost you thousands of dollars. It could even expose you to years of litigations. Most beneficiaries don't know what they're releasing until it's too late. Here's what most people don't understand. When you release a trustee in Florida, you're giving up your right to hold them accountable. You're essentially saying, I agree that everything was done correctly. That's a massive statement. Once that release is signed, going back becomes incredibly difficult. The law assumes you knew what you were doing. The courts won't help you if you simply changed your mind later. I've seen this scenario play out dozens of times in my practice. A beneficiary receives a final accounting. They glance at it. The numbers look reasonable. They sign the release. 6 months later, they discover something was wrong. Maybe an asset was undervalued. Maybe distributions weren't made properly. And maybe there were questionable expenses. Now they want to challenge the trustee. But that release they signed, it's like a fortress protecting the trustee from liability. The first thing you absolutely must review is the accounting itself. Don't just skim it. Actually read it line by line. I know it's tedious. I know it's boring. But this is your money we're talking about. Look at every asset that was in the trust when it started. Look at what happened to each one. Was property sold? Who bought it? What was the sale price? Did the price match fair market value? These questions matter. A trustee has a duty to get the best price possible when selling trust assets. If your aunt's house was worth $3 million, but the trustee sold it to their cousin for $200,000, you have a problem, a very big problem. Check every distribution that was made. Who received what? When did they receive it? Does this match what the trust document actually says? Sometimes trustees get creative with distributions. They might give themselves more than they're entitled to. They might shortchange certain beneficiaries. They might make distributions at the wrong time. The accounting should show you all this, but you have to actually look. Now examine the expenses. Trustees are allowed to be compensated. They can deduct reasonable expenses. But what's reasonable? That's where things get tricky. A trustee who charged $50,000 for administration fees on a $300,000 estate better have detailed records. A trustee who billed for hundreds of hours of research needs to show exactly what they were researching. Now, if you're finding this information valuable, do me a favor right now. Hit that like button below this video and subscribe to my channel. I release new videos every single week on Florida trust and estate issues. These are the things that protect your wealth and your family's future. Now let's talk about something most people completely miss. Right, now the second major thing is what most people miss. It's what's not in the accounting. This is where trustees hope you won't pay attention. Was there an asset that you remember being in the trust that's not listed? Ask about it. Demand an explanation. Assets don't just disappear. Were there income-producing assets in the trust? Well, where's the income? If the trust owned rental property for 2 years, there should be rental income shown. Now, if the trust had investments, there should be dividends or interest. If these aren't documented, something is wrong. Look for gaps in time. The accounting should be continuous. If the trust existed for 5 years, you should see 5 years of activity. If there's a year missing, that's a big red flag. What happened during that time? Where did the money go? Also, check for personal expenses that might have been charged to the trust. Did the trustee bill for meals, travel, office space? Some of these might be legitimate, but many are not. A trustee can't take their family to Disney World and charge it to the trust just because they had one phone call about the trust while they were there. Third, you need to verify that all legal requirements were actually followed. This is huge. A trustee has specific duties under Florida law. They can't just wing it. Did the trustee provide notice to all beneficiaries as required? Florida law says beneficiaries must be informed about the trust and their rights. If you never received proper notice, the trustee failed in their duty. That's grounds to refuse the release. And were all creditors properly notified and paid? Florida has specific procedures for handling creditor claims against trusts. Now, if the trustee didn't follow these procedures, the trust could still be liable. That means you could still be liable. Don't release the trustee until you're sure all legitimate debts were handled correctly. Also, was the property in the trust properly maintained? If the trust owned real estate, was it insured? Were taxes paid? Was necessary maintenance performed? A trustee who has let property fall into disrepair or gets foreclosed has breached their duty. You need to know about this before signing anything. Next, did the trustee keep trust assets separate from their personal assets? This is called the duty not to commingle. A trustee who mixed trust money with their own money has committed a serious breach. This can be hard to detect, but if you see transfers between the trust and the trustee's personal accounts without clear documentation, investigate further. And fourth, and this is critical, get your own attorney to review everything. Don't rely on the trustee's lawyer. That attorney represents the trustee, not you. Their job is to protect the trustee. Your interest might be completely different. An experienced trust attorney can spot issues you'd never see. They know what to look for. They understand the legal standards. They can tell you if something that seems minor is actually a major breach of duty. Yes, this costs money, but consider what you're protecting. If there's a $100,000 mistake in the accounting, spending $2,000 for an attorney review is smart business. If there's nothing wrong, you have peace of mind. If there's a problem, you've saved yourself from signing away your rights. Also, consider getting an independent appraisal of any significant assets. The trustee might have used their buddy to value the property. The appraisal might be wrong. A truly independent expert can tell you if values are accurate. Remember this, a release is permanent. Once you sign it, you've accepted everything the trustee did, good or bad, right or wrong. The courts will hold you to that signature. So slow down, take your time, review every page of that accounting. Ask questions about anything you don't understand. Verify that all legal duties were in fact fulfilled. Get professional help when you need it. Don't let anyone pressure you into signing quickly. If the trustee says everyone else has already signed or we need this done by Friday, that's not your problem. Take the time you need to protect yourself. Your signature on that release form is valuable. It's protecting the trustee from liability. Make sure you're comfortable giving that protection before you sign. Now, if you found this video helpful, please hit that like button, subscribe to my channel for more videos on Florida trust and estate law. Leave a comment below if you have questions about your specific situation. I'm Santiago Cueto, your Florida business attorney. Be sure to stay and watch more of my videos right here.